Hi, I'm Diane Drain, Arizona bankruptcy and foreclosure expert and law professor. I want to talk about the Chapter 7 process and how it works. Basically, when an individual or a company files for bankruptcy, they're required to fill out a whole series of documents. It's quite extensive. So for an individual, you're looking at basically a minimum of 70 pages. For a company, it could go on for hundreds of pages. Those documents reflect the things that the individual or the company owns and owes. By law, every debt must be listed. Then there's a historical summary of the things that have gone on, like payments made to others, etc. Those documents are all signed under penalty of perjury, so it's really, really important that whoever is filing this bankruptcy understand they have to be thorough, accurate, and honest. Otherwise, this could come back to bite them big time. And so the documents are filed with the court. At that same time, there'll be a bankruptcy trustee assigned, kind of like a babysitter. And that trustee's responsibility is to go through all the documents, to ask for extra information like bank statements and tax returns and pay stubs. The trustee then conducts what's called a creditors meeting. Now, it's very rare in an individual case for creditors to be there, but they could be. In a commercial case or a small business, certainly there's most likely going to be creditors there. But at that meeting, what the trustee does is have the debtor swear under oath. They did review the documents. They are true and accurate. And then take them through a series of questions about where they've lived prior to filing the bankruptcy, and did they have any inheritance, and questions like that. For the individual that has prepared their documents correctly and gotten good legal advice prior to that, most likely that meeting will last 2 minutes. For the individual who did not prepare it properly or got really bad legal advice, maybe none at all, unfortunately it could last for a while, and it may result in a follow-up meeting with the trustee or their attorney called a 2004 exam. So again, accuracy is extremely important. So at the end of the meeting then, that will most likely conclude the relationship with the trustee for that minute. There's a second class that has to be taken in a bankruptcy called a financial management course, so that will be the certificate filed with the court. Now that's only in the consumer case, not for the commercial or small business case. That certificate is filed. There may be additional documents that the trustee has requested, like maybe a brand new tax return, so those have to be sent to the trustee. The discharge, which is the important reason why the individual or the company has filed bankruptcy. The discharge for an individual will come anywhere from, say, 90 to 120, 150 days after the bankruptcy is filed. For a company, though, they will not get a discharge. In essence, the company has pretty much closed its doors and all of its things will be liquidated or sold. Back to the individual, though, if the individual owns assets that are not on the exemption list, and I have another video titled Arizona Exemptions, then the trustee has the obligation to liquidate those items and use the money to pay some fees to the trustee, and maybe they've hired an attorney, and then the balance of the monies go to the creditors. If you fail to provide the trustee with the information he's requested, he could actually ask that the court revoke the discharge. Once the trustee has done his job, the file will be closed. So the two events that are really important in a 7 for an individual is not only the discharge, but the closing of the file. Now, if there has been any lying, the trustee can then reopen the case, or a creditor can reopen the case. The judge can revoke the discharge and start hammering that poor debtor. So again, it's really important to be honest. I can't stress that enough. There are some bankruptcy videos at our website done by the the Federal Bankruptcy Court that explain the process, and so that'd be a good thing to watch. For the commercial Chapter 7, as I said, they will not get a discharge. The trustee, again, has their own responsibility as far as liquidating assets and then paying out the money. So that should be the end for the Chapter 7. If there were some undisclosed assets, though, like failure to list something valuable, then unfortunately the case can be reopened in the process and starts on again. So I hope this was helpful in understanding how a Chapter 7 process works. Thank you.